Maybe you're not exactly sure what you need in your estate plan. You probably think to yourself, well, I know I need a will. I need a will, but what else do I need? So I'd like to talk to you about the essential documents you need in your estate plan. So let's start with the will. The will is what says where your assets go when you're gone and who gets what. And your will can include protections against creditors and all sorts of threats to the money that the person who is inheriting from you, they might be facing. So yes, you need a will. A will has no effect until you are deceased, until you passed away. So the will is just sitting there waiting to come into effect and act upon your death. Well, what's more important than that? In my opinion, as an estate planning and elder law attorney, what's more important than your death document is what's in effect when you're alive to protect you. I call these your living documents. In fact, you probably have heard the term living will. A living will is not a will at all. It is an advance directive. It's a healthcare directive. The living will, as the term is used, is meant to say what your wishes are if you are at end of life. Do you want heroic measures? And if so, what measures do you want? What measures do you not want? So that's what a living will is, and that is an essential estate planning document, and it's what I call a living document. There are two other very important living documents. They are your powers of attorney, your durable powers of attorney. I said two documents. A durable power of attorney can address both important issues of your finances and your medical or personal wishes. They can be combined into one document, but I say two documents because at ELG Estate Planning, we do separate powers of attorney. One is what we call a general durable power of attorney, and that's to address all your financial, your business type issues. The other is your healthcare power of attorney, and that's where you grant authority to someone, your attorney, in fact, your healthcare agent, they mean the same thing, to speak on your behalf if you're not able to talk to the doctors and express what your wishes are. You want to appoint somebody that you know, who you trust, who knows you well, who will be your voice when you can't speak for yourself. And your healthcare agent would make sure that your healthcare directive, your living will, is also honored by the medical profession. Because the healthcare power of attorney really speaks to personal medical issues, and the financial speaks to more financial issues, paying your bills, your investments, possibly selling your house, applying for Medicaid, we separate out those documents because those are very different powers, and you might want different people in serving in those roles. Maybe one of your children is going to be great with healthcare and the other one is going to be great with finances. So we do separate out those documents. They're called durable powers of attorney because if you should lose capacity, the ability to manage your affairs, these documents stay in effect and protect you and grant the authority for finances and for health. So your document must be a durable power of attorney. So what are your essential documents? Your living documents, your living will, and your general durable power of attorney for finances, and your healthcare durable power of attorney. Those are your living documents. We talked about the documents that take effect upon death. That is your will. Now, I do want to mention that oftentimes people are interested in trusts, especially revocable living trusts. That's because a revocable living trust is set up to avoid probate, and in some states it's important to avoid probate. California, for example. So a revocable living trust is another document that will say on your death where your assets go. It's intended to avoid probate. Keep in mind that if you have a revocable living trust, you are also going to have a will. So those are the essential documents. And why do you need a will? Why did I just say if you have a revocable living trust, you need a will? It's because oftentimes people forget to put all of their assets into the trust. So there ends up being a trust administration plus a probate, even though the plan was to avoid it. So there's always going to be what we call a pour-over will if you have a revocable living trust to avoid probate. So those are your essential estate planning documents that everyone needs regardless of your asset level.